Hey YouTube, my name is Natalie. I'm a criminal defense attorney and welcome to my channel. So in today's video, we are going to be covering the case of Shanteri Weems, and I actually have some exclusive information for you. So the case of Shanteri Weems is a recent breaking case here in the Washington, D.C. area. And I had the advantage of being able to watch the preliminary hearing. As a brief background, Shanteri Weems and James Weems Jr. are a married couple, and on July 21st of 2022, officers responded to the Mandarin Hotel in Washington, D.C. For reports of someone being shot. And the person that was shot was James Weems, and Shanteri Weems, his wife, shot him because allegedly he had been the children that were in her daycare. Shanteri Weems owns a daycare in Maryland, in the Baltimore County area of Maryland. And a mother had recently come forward to her the same day that she had shot him, saying that James Weems had abused one of her children. It also came to light that he may have potentially been abusing other children that were in Shanteri's daycare. This case, I think I tweeted about it because, I'm going to be totally honest. When you hear someone shooting an alleged abuser of children, it's really hard to feel sympathy and empathy for that person. But we have the ethical rule and then the rule of law, right? And all of those things don't always match up with each other. And so I think this case is a perfect example of that. So I listened into the preliminary hearing, and it dealt with two things. Number one, was there probable cause for Ms. Weems to be charged with the felony of aggravated assault and assault with a deadly weapon, which were her two charges. In addition, the other issue was whether or not Ms. Weems was going to be released on pretrial release or held at the local D.C. County jail, or D.C. County, at the D.C. jail. It's not a county, at the D.C. jail. So let's start with the hearing. So I watched the entire hearing. At the outset of the hearing, the government attorney stated that she had several exhibits that she wanted to introduce, but that one of them was particularly graphic, and so she didn't want to display it on the screen. The hearing was held via WebEx. However, the judge said that she didn't want any of the exhibits displayed on the screen. The public was present, like WUSA was present, ABC News was present, so she didn't want the exhibits displayed on the screen. She wanted them directly showed in the printed copy to the witnesses because everyone was present in the courtroom. Nobody was virtual that was participating in the hearing. The only people that were virtual were the observers. So the government first called a detective by the name of Andrew Gong, G-O-N-G, who is a detective with the Metropolitan Police Department. He's been with the MPD for the past 6 years, and he's assigned to the 1st District. He said that on July 21st of 2022, he responded to the Mandarin Hotel, or the Hotel Mandarin Oriental. There was an incident on the 8th floor in which a male victim had been shot in room 853. They ID'd Ms. Weems in court as being the suspect in the case, or the defendant, because when he arrived, he had the opportunity to speak with Ms. Weems and say that this is Ms. Weems. The same person that I spoke to on July 21st is the same person at the preliminary hearing on July 27th. The time that Detective Gong had made entry into the bedroom, or into the hotel room, officers had already arrived in the hotel room. This is all under direct examination, and he says that those officers, based on what he was told, were not able to immediately enter into the hotel room because the room was barricaded for approximately 30 minutes. They could hear that there was a female inside, and the female was saying that everything was okay. And he was not sure how officers were eventually able to make entry into the hotel room. They said that once they arrived, there was a male victim inside the hotel room that had been shot. There was blood on the floor in the bathroom and blood in the hallway. There was a gun in a black handbag and a gun in a lockbox that was unlocked and open. The victim, James Weems, said that he had been shot And Shantari Weems, the alleged perpetrator, was also present. The detective Gong described the room as being in disarray with clothing, blood, and cell phones all over the floor. There was blood in the hallway. Then the government went to introduce in 3 exhibits, Exhibit 1, Exhibit 1A, and Exhibit 1B. And these were various photos of the hallway with blood. Exhibit 1B had a picture of a dresser and a lockbox. The alleged victim, James Weems, and the alleged perpetrator, Shantari Weems, were removed from the room, and a search warrant was obtained, and then a further search was done of the room. James Weems was taken to the hospital, and then he was released into the custody of law enforcement because he was arrested on July 27th of 2022 on charges of child molestation in the state of Maryland. He is a former Baltimore police officer. So Mr. Weems is a former Baltimore police officer, and Mrs. Weems is a former correctional officer. He is now currently being held in a detention center in Maryland. He is currently being held in a detention center in the District of Columbia. He is awaiting to be extradited into Maryland. The reason that he's being held in the District of Columbia is because he was hospitalized in D.C., but the daycare is in Maryland, and that's where the child abuse allegedly occurred. There were 2 firearms recovered, as I said, 2 shell casings, a notebook, cell phones. Gun 1 was found in a black handbag. Gun 2 was found in the open lockbox. There were exhibits entered that were pictures of a pistol in a holster that was in a lockbox, and of a handgun and a black handgun, and of a firearm. So there were shell casings next to a chair and shell casings in a hallway underneath a mirror. Exhibit 4 showed those shell casings. There was also Exhibit 5, which was a picture of the hole in the wall in the hallway. And during the government's argument, they said that that hole in the wall came from one of the bullets going through the wall. And the government contended that that's what made Mrs. Weems a danger to the community, because she shot Mr. Weems in a hotel where there are innocent civilians present. So someone else could have been injured if the bullet had gone all the way through the wall. The notebook in the bedroom that was found on top of the dresser was of note. It was open and there was writing in it, and the writing said, "I'm on my way to shoot James. I don't intend to kill him. I want to hurt him. I want justice." That's a general quote from Detective Gong on direct examination. That's not a direct quote. Also, as she was being led out of the hotel room, allegedly Mrs. Weems said he molested the children and she was going to walk out proud. There was 1 gunshot wound to the neck of Mr. Weems and 1 gunshot wound to the left thigh of Mr. Weems. There was also some allegations that while the hotel room was barricaded, Mrs. Weems, Shantari Weems, said that she wanted the police to kill her. Now, James Weems did make a statement, and he said that they were arguing and that she shot him. He did not deny the allegations of molestation. Detective Gong was then cross-examined by Mr. Garcia, the attorney for the defense. And he said that on cross-examination, when he said the room was barricaded, he did not mean that it was barricaded by, let's say, like a couch or a chair pushed against the door. That instead, it seems like the door was just locked, and then they needed to make entry, and they didn't unlock the door. So when they say barricaded, it's a bit overblown. That's not what they meant. The door was just locked. She gave statements to officers when they arrived that she indicated she confronted him regarding the molestation, and that he advanced towards her. And when he advanced towards her, that's when she shot him. She was in fear of him because she knew him to be a licensed firearm carrier, and she was also a licensed firearm carrier. She said that she knew that he was armed. Apparently, he is also a former Marine, but the Detective Gong did not know that, but he was also a former Marine. He was a retired police officer, and it's possible that he works in some type of armed security capacity currently, but the detective didn't know about that. She did say that there was a physical advance towards her. Now, there was a quibble between the defense attorney, Mr. Garcia, and the Detective Gong, as to whether or not she stated that she was in fear. So Mr. Garcia asked, did she say she was in fear? And Gong said no, she said she was confused. And he kept trying to go back to that, Garcia, and trying to get him to say that she thought she was in fear. But in fact, Gong would never say that. Gong said that she was confused. She said that she did shoot. It was very clear that she shot him after he advanced towards her physically. And he does not know whether or not the gun that is believed to be Mr. Weems's gun is the gun in the safe. He doesn't know whether or not the gun that was in the open safe was in the safe before or after the shooting. So there's no evidence of whether or not Mr. Weems was holding the gun at the time that Mrs. Weems shot him. He says that the only word that she used was advance and not attacked. So then on redirect examination, so now this is the government questioning Detective Gong, there had been no previous domestic violence calls between the Weemses, no 911 calls, no allegations of domestic violence. That she and Mr. Weems, or she herself, had come into Washington, D.C. quite often, and that's pretty normal if you live in Baltimore to go into D.C. often and vice versa because, they're at close proximity, major cities close to one another, and that she had never brought her licensed gun with her before going into D.C. She doesn't usually bring a firearm. There was no mention of a threat made towards her or her being in fear of him, solely that she was confused because of the whole situation, and that the detective did not believe that she expressed that she was fearful. So basically the reason that they were in D.C. is because Mr. Weems participates in something called the Urban League, and he travels for the Urban League. And this time he traveled into D.C. Again, it's like 45 minutes away, but traveled into D.C. for the Urban League. And so Mrs. Weems came with him, that they acted normal on that day, July 21st of 2022. They were hugging, they were kissing. And other than saying that she was confused as to the situation, she did not seem like she was in fear. Then at that point in time, the state, or the government, as they're called in D.C., the government rests. The defense attorney asked for an opportunity to recross or ask some more follow-up questions. But in Washington, D.C., it's not allowed. It's not allowed in most places to give the defense a chance to re-ask questions after the state has redirected. So the judge denied that. So the judge found that there was probable cause as to aggravated assault while armed and assault with a dangerous weapon. The judge looked to the jury instructions for aggravated assault while armed and assault with a dangerous weapon and found that even if she were to advance a defense of self-defense, there was not enough evidence here during this preliminary hearing that she was acting in self-defense because there was no statement from her that she was in fear or that he attacked her, or that he was holding the gun at the time that he advanced towards her. Basically, the use of the gun would have been a disproportionate response if, in fact, she was in fear and acting in self-defense based on what the probable cause is. Probable cause is a very low standard. It's basically, is there any evidence that is there to suggest that there is a reason to believe that this defendant committed this crime as it is charged? The judge also pointed to the fact that she recognized that there were allegations that Mr. Weems had sexually assaulted some of the children in the daycare, and that, in fact, he had been arrested for assaulting some of the children in the daycare, but that was not of legal relevance because the the personal reason for which you begin a confrontation with somebody is not really at issue unless you are acting in self-defense. It's not a defense to the crime that the person is a bad person, basically, is what she got to. She also said that although the lockbox was, open, the gun was still in a lockbox. So that would lead her to believe that he was not holding a gun at the time that she shot him. So I directly quoted her here where she said, the reason to confront is not a consideration in determining whether or not there was probable cause. People have reasons for having disagreements and arguments all the time. It's not a defense to aggravated assault while armed or assault with a dangerous weapon. Or at least it's not a consideration in a probable cause hearing. Now, what is going to play out in the trial is unknown, but not for a very low standard probable cause hearing. So then the government made a motion saying that they were seeking what's called continued detention. So she's already being held. And DC has some very unique case law over holding people pretrial. And in order to continue to hold someone, you have to show that several factors are met, including that this was a crime of violence. So there's a rebuttable presumption under DC case law, which means that we presume this person should be held, but you can fight against it as the defense. There's a rebuttable presumption that she should be held because what she was charged with, the aggravated assault with a deadly weapon, is a violent crime. And in addition, they believe that the further extenuating circumstances were that it occurred in a hotel, the bullet hit the wall, and they could have killed or harmed somebody. She could have killed or harmed someone else. And also that she entreated the officers to use deadly force against her, so she could potentially be not only a danger to herself, but also a danger to the community. She also pointed out, this is the government attorney I'm talking about, that the husband, Mr. Weems, had been placed under arrest and was currently in the infirmary. However, they don't know what his pretrial release conditions are going to be. He could potentially get out, and they don't want her to be a danger to him in particular. So in response, Mr. Garcia, attorney for the defense, gave several factors when talking about the fact that Mrs. Weems was not a flight risk and she was not a danger to herself or a danger to the community at large. So he pointed out that Mrs. Weems is 48 years old. She would live somewhere else with a person that she knows. I'm not going to say that person's name, but a person that she knows that has lived in their own address for the past 8 years that has no criminal history. They would act as a third-party custodian to ensure her presence in court and that she doesn't get in trouble. She had been a correctional officer. Mrs. Weems had been a correctional officer for 10 years before she opened her daycare in 2003. She had no arrests and no previous convictions, not even any civil sanctions. She's a licensed gun carrier, and the gun was confiscated in the case, so she doesn't have any access to handguns. There were several character letters that were written on her behalf for the court to consider. Some of those included letters from children at the daycare. One such person, I won't say her name, said that Mrs. Weems was gentle, kind, a peacemaker, and that she was a needed member of the community, that she helped out with the community. One person who was a director of the daycare but also had kids in the daycare said that she was generous and kind and was always there for other people. And then a gentleman said that she was calm, collected, and a protector of the community. Mr. Garcia also said that in order to ensure her presence in court, Mrs. Weems would surrender her password, and that they would, ask that maybe she be placed on electronic monitoring instead of holding her in jail. He asserted that she was not a danger to anyone. She was not a danger to anyone. That day a mother had come to her and said, "Your husband abused my child." And she, in the body-worn camera during her interview, you can see that she says that when she confronted him about it, she thought that he was just going to deny it. But instead of denying it, he became aggressive and went from 0 to 100. She wanted him to deny it, but he would not. So she wanted him to face justice. Allegedly, 3 children in her daycare were molested by him. So the judge went on to make her determination, and she said that people have conflicts, and the allegations against him are very serious. But just like Mrs. Weems does, Mr. Weems has a presumption of innocence. She chose to take it upon herself, and she committed one of the most serious offenses of the utmost dangerousness. So she found that dangerousness was a serious factor here. She recognized that Mrs. Weems had no prior history and that she had previously been a correctional officer. But she said that the fact that she was a correctional officer previously went against Mrs. Weems's favor. And the reason that she says that was because I believe she thought that the letter or the notebook that she left open saying that I wanted to bring him to justice and I don't want to kill him, and then proceeding to shoot him in the neck, she thought that that was calculated. And she thought that that was not in her favor. It cut against her. The judge recognized that Mrs. Weems had community support and that the third-party custodian was available for her to have a place to live. She hopes that she continues to have that community support, but the court was concerned about community safety overall. The request for continued detention was granted, meaning that until her next court date, at least, Mrs. Weems is going to be held at the D.C. jail. After the judge ordered that probable cause should be found and that Mrs. Weems should continue to be held, there was an outcry in the courtroom. I got some quotes of some things that people were saying. They were saying, well, what about the children? Don't you care about the children that were molested? That people were told to mute or to be expelled. Some said that she was only being held because she was a black woman. Some were told, some people said, excuse me, I'm trying to find my note here. Some people said that it was outrageous, that it was heartless. And I want to be clear for the context here. The very beginning of the hearing, the judge told all of us that we're not allowed to record and that we needed to keep our mics on mute. So that's what we did. Nobody, I hope so. I didn't record. It would have been great if I could have recorded so I could have showed you guys what I'm talking about. But I definitely kept my mic on mute. People were purposefully unmuting themselves in order to protest the judge's ruling. The judge said that she would remove them virtually from the virtual courtroom if they did not stop the outcry, but they continued to outcry in the court about her being held pre-trial. As a result, the judge removed herself from the bench, and then I saw the courtroom bailiff go over and turn off the sound for the WebEx, which meant that we could still hear everyone, but I don't think the court could hear us. And then about a 10 to 15 minute recess proceeded, and then the judge got back on the bench and called a different case. So that was the hearing for Miss Weems. Probable cause was found. Here's my thoughts on it, or my analysis, I guess is the best way to put it. I do believe that there was probable cause for the, aggravated assault with a deadly weapon. I mean, basically, she admitted to it, and it's very sad. It's horrendous. It's sad. But unfortunately, the risk of taking the law in your own hands is that you don't have, as far as guilt and innocence is concerned, a legal justification for what she did. Premeditating to shoot someone in the neck and the leg because of something horrendous that you believe that they did. The court system is going to be against that because they want to encourage people to avail themselves of the judicial process. But I can understand. I think in my initial tweet, I said, it kind of like is what it is. I can understand why she did what she did, but the consequences are going to be that you're going to be held in jail. Now, do I think that she would actually be a danger to people in the future? No. I mean, the woman is over, 49 years old? Was she 49 or 59? I couldn't remember which one. So she's 48 years old. So she's a mature woman who has no criminal history. I don't think that she would just start going on a killing spree or anything like that. I don't think she's a danger to anybody but him. However, I don't know. The attorney that was hired, Mr. Garcia, he did a great job at the preliminary hearing. He did a great job at the detention hearing. I really think that he did a great job. However, I don't think he's a DC attorney. He seems to be a Maryland attorney appearing pro hoc vice because there was a DC attorney there with him who didn't speak. So when you appear pro hoc vice, it's when an attorney uses their license to allow you to appear in just one case and they sit the case with you. They're supposed to be lead counsel, but usually, the person that's being allowed in pro hoc vice is being hired by the defendant because that's who they trust or that's who they like or whatever the case may be. But there is DC case law, so I'm just saying all that to no shade to Mr. Garcia. I think he did a great job. But there is DC case law that the judge should consider to release the person even if they have committed a violent offense or they're alleged to have committed, that's the thing to remember. The person is alleged, even with all of these, allegations in court, even if there's a full-on confession, they're still alleged until they're found guilty by the finder of fact, which in this case will likely be a jury, right? So they're still they're still not guilty until found guilty in a court of law, right? Even at this stage of things, even with these facts, she's still not guilty. And so a person like that with no criminal history, courts have said there's in DC that you should consider to release them if they have absolutely no criminal history, because the consideration is dangerousness to the community and flight risk. Those are the two key factors. And there's like sub factors to determine that. And so they're not saying, did the person commit this crime? That's not really what it's about on pretrial release. What it's about is while they are awaiting their conviction, because it's not supposed to be punishment. It's just supposed to ensure your presence at trial and the safety of the community. While you're awaiting an adjudication of guilt, are you going to go out on a spree and start hurting people? Or are you going to do something else similar to this? And if you have absolutely no criminal history whatsoever, it should weigh in favor of your release. So, I think the judge could have released her. The judge made a sound decision. I understand how the judge reached that decision, but I think the judge could have released her under that case law, but it was up to Mr. Garcia to bring up that case law to the judge. And I wonder if maybe Mr. Garcia wasn't aware of that case law. I'm sure that after this hearing, he'll hear from other attorneys who might tell him, or he'll do some research like, hey, look into this case. It's DC specific, because Maryland does not have a case like that, right? You shoot somebody, more than likely you're going to be held pre-trial. A two-time contact shooting, more than likely you're going to be held pre-trial in the state of Maryland. But in DC, because they have that specific case, if her attorney looks into that, he might be able to file a motion in the future to say, hey, look, the court didn't consider this case on the record. If you could please consider this case now. Maybe if some of the discovery changes things or something, they might be able to file a motion to maybe potentially get her out, because she really has nothing, no criminal history whatsoever. So I think the judge was totally justified in finding probable cause, because again, is there any allegation that's made that the elements of the crime have been committed? Yes, there is an allegation made based on those facts that the elements of the crime have been committed. So I don't really think the judge had any choice but to find that there was probable cause. However, I do think the judge had a choice to release her under DC case law. And I just kind of wish that she had been released, but I understand why the judge did not release her with the presentation that she received in court. And also, it's kind of like common sense. Like, you shoot somebody, allegedly, there's this much probable cause of it, and allegedly it happened in a hotel room. I'm going to be concerned that you would disregard the safety of others in the future. So anyway, I'd love to know what you guys think. Please comment down below. I really enjoyed the discussion with you guys, and I will talk to you later. Bye. Oh, and if you want me to cover more of this case, I can follow the next court dates. They're not all going to be virtual, but I can follow the upcoming court dates and watch them, or maybe like if I have time, pop over to DC Superior Court to go watch it and then report what it is that I found in this case. If you guys are interested, let me know. I'll talk to you later. Bye.